Imagine this. You're about to close on a property. The financing is locked in, the title search comes back, and then right there in the county records, someone you've never met has filed a document claiming they have a contractual interest in your property. Your lender pauses, your title company gets nervous, and your deal is frozen. This happens more often than you think, and until recently, there wasn't a fast way to fix it, but that just changed. I'm Hamilton Rucker, a Texas real estate attorney, and today we're breaking down House Bill 4063, a new law that took effect September 1st, 2025. This law gives property owners a powerful new tool to fight back against abusive title filings without stepping foot in a courtroom. So, whether you're a property owner, an investor, a lender, or a title professional, stick around because this one could save you months of headaches and thousands of dollars. How memorandum contracts disrupt deals. Okay, so to understand why this law is such a big deal, let's talk about how this problem actually plays out. A memorandum of contract is a document that gets recorded in county records. It basically announces to the world, hey, I have a contract involving this property. Now, when both parties sign it, that's fine. That's the normal thing. That's how real estate usually works. But here's the problem. Sometimes a person files a memorandum unilaterally, meaning the property owner never signed it. Maybe they never even knew about it. And once the document hits the county records, it creates what we call a cloud on title. Now, any buyer, any lender, any title company that sees this filing has to stop and ask, wait, is this a real claim? And here's where it gets ugly. The person who filed it may come to the property owner and say, pay me to release this. That's not a negotiation. That's a leverage through paperwork. Some sort of blackmail, also referred to as greenmail. And until now, the property owner's main option was to go to court, hire an attorney, wait months, spend thousands, all while the deal sits in limbo. House Bill 4063 was designed to break that cycle. House Bill 4063, the equalizer. So what does House Bill 4063 actually do? It adds section 12.020 to the Texas Property Code. It creates a fast but out-of-court process for dealing with abusive memorandum filings. No courtroom, no judge, no months of litigation. Instead, it's a notice and affidavit procedure with strict timelines built right into the statute. But here's the part that really changes the game. It flips the burden of proof. Before this law, if someone filed a memorandum against your property, you had to prove their claim was invalid. You were on defense from day one. House Bill 4063 is the exact opposite. The person who filed the memorandum has to prove their claim is legitimate. If they can't, the memorandum gets neutralized. That single shift changes everything. Before versus after, the shift in leverage. Let me paint the picture so that you can feel the difference. Before House Bill 4063, someone files a memorandum. You find out about it, and when your title company flags it, you're scrambling. You hire a lawyer, you file a lawsuit, you wait for a court date. Meanwhile, your buyer walks. Your lender pulls out, and the deal dies. After House Bill 4063, someone files a memorandum, you respond within a statutory affidavit period, a 45-day clock starts, ticking from there on. And if they don't prove their claim is in that window, done. The memorandum loses its power. Your deal moves forward. We went from open-ended litigation to a 45-day resolution track. This law imposes strict certified mail requirements at every step. So there's no ambiguity about who knew what and when. The action response workflow. All right, let's walk through exactly how this works, step by step. Step one, someone records a unilateral memorandum of contract in the county records. Step two, that person is required by law to send a certified copy of the recorded memorandum along with a statutory notice to the property owner. This is not optional. If they skip this step, the memorandum loses its legal effect right there. Let me say that again. If the filer does not give proper notice, the filing has no ability to work. Step three, if the property owner receives the notice and disagrees with the claim, the owner records a disputing affidavit in the county records. Step four, The owner sends a certified copy of that affidavit to the filer, and that's when the clock starts. The countdown, the 45-day clock. This is where House Bill 4063 gets its real power. Once a property owner records and delivers the disputing affidavit, the filer has exactly 45 days to respond. And this isn't just send an email saying I disagree. They have to record a responsive affidavit that actually demonstrates their claim is backed by a legitimate contract. 45 days, that's it. No extension, no excuses, no I didn't get the notice. And if that 45-day passes without a response, well, it's over. Day 46, the legal effect of silence. Here's what happens on day 46 when that deadline passes. 1, the memorandum is no longer constructive notice. It's still physically in the county records, but legally it's been removed. 2, buyer and lender have no duty to investigate the claim. They can proceed as if it doesn't exist. 3, the property can be sold, financed, or encumbered free of the memorandum, even if someone previously knew about it. In plain English, the title is cleared. The deal can close. The fine print, title versus contract. Now I want to be upfront about something because this is an area where people get confused. House Bill 4063 is a title records law. It governs what is in the public records and how that affects real estate transactions. What it does not do is erase actual contracts. So let's say someone files a memorandum, it gets neutralized through the 45-day process, but they genuinely did have a valid contract with the property owner. They can still go to court and pursue a breach of contract claim. That law doesn't kill their contract rights. It kills their ability to weaponize the county records to hold a deal hostage. And that's an important distinction. The playbook, practical steps for investors and title companies. All right, so what should you actually do with this information? Here's your playbook. You need to audit your county records before any closing, run a fresh title search, and if a memorandum shows up, check the date. Was it filed after September 1st, 2025? Is it a unilateral filing? If yes, you may be able to use this statutory process. Do your documents have everything with certified mail? The entire process lives and dies on proof of delivery. Every notice, every affidavit, send it certified, return receipt requested, keep copies of everything. And then there's number 3, train your team. If you work with acquisition teams, brokers, or title professionals, make sure they understand the 45-day timeline and the statutory forms. The last thing you want is delay because someone didn't know the process. This law only works if you use it, so be proactive. The big picture, systemic impact on Texas real estate. Let's zoom out for a second and talk about what this law means for Texas real estate ecosystem as a whole. For property owners, it means you're no longer at the mercy of someone who can file a piece of paper and hold your property hostage. You have a clear, fast plan to fight back. For title companies, it means you now have a statutory method for clearing title clouds without waiting on a court order. That's a game changer for closing timelines. For lenders, it reduces underwriting risk. If a memorandum gets neutralized through the statutory process, you can move forward with confidence. And for investors, it means deal flow gets faster and more predictable. You no longer are held up by claims that may have no substance behind them. This law strengthens the entire transaction pipeline. So, deals should be dictated by contracts and not by coercion. Real estate deals should be governed by legitimate agreements between real parties, not leverage created through questionable filings. This House Bill 4063 is a statement from the Texas legislature that the title record system should protect transactions and not be used as a weapon against people. So if you ever find yourself staring at a memorandum you didn't agree to, remember you now have 45 days to make it disappear. If this breakdown was helpful, do me a favor, hit the subscribe button. I'll put out more content regularly on Texas real estate law, investment strategies, and legal insights you need to protect your deals. If you got questions about memorandum contracts or anything else in Texas property law, drop them in the comments. I read every single one. I'll see you in the next video.